Hi, everyone. My name is Madelena Viksne. I'm an employment lawyer at Superior to Markin, and I am here to answer all your questions today. I thought that before we get kind of started on the question portion, that I would talk to you and let you know about a pretty terrible but also important case that one of my colleagues is taking on that was in the news yesterday. Um, 5 former employees from a company called Coventry Homes, which is a new home builder in Edmonton, Alberta, have filed lawsuits against the company for sexual harassment, failure to provide a safe workspace, retaliation against employees who spoke out about these types of things, and other employment related claims. My understanding is that this is a pretty deeply rooted issue within the company, and five employees coming forward kind of amplifies and confirms that. And these employees are seeking justice for the harms that have happened to them in the workplace. So on that note, I thought that I would sort of discuss the general, I guess, employment issues relating to sexual harassment and harassment in the workplace. And one of the things that you should be aware of is that keeping contemporaneous records is really important, as is reporting it to somebody who, because reporting it to somebody who should take action of some kind on your behalf to deal with the report of serious misconduct in the workplace triggers the employer's duty to investigate. And I think that it's a little bit unclear sometimes to employees that they do have rights in this regard. Not that people believe that harassment in general is acceptable, but that they have actual employment rights once they've reported something in the workplace. As in under the Occupational Health and Safety Act, the employer has to take certain steps, and their legislated steps, in order to address or investigate or deal with those issues. What dealing with those issues might actually entail depends very much on, what is reported and how, when, etc., as well as what is reported, as well as who it's reported to. But what I mean by that is only that reporting to the right person and reporting as early as you can with some kind of contemporaneous evidence, if you have it, is important. And it actually triggers the employer's duty to investigate your allegations. And when the employer's duty is triggered, duty to investigate is triggered, that employer has certain obligations under the law, under the Occupational Health and Safety Act of your province, to proceed through a certain type of process. And once their independent investigation, or supposed to be independent investigation, has been completed, you have the opportunity to and the ability to look outside of your employer for additional assistance. So if, for example, something's happened in your workplace that constitutes harassment or sexual harassment, you report it to your employer and they do nothing, they've breached the Occupational Health and Safety Act. If they do an investigation and they fail to find on your behalf, and you feel like that is an incorrect decision, then there is actually a statutory appeal process that you can follow through which will assist you in challenging the decision that has been made. As I said before, and I put in quotes, it's supposed to be an independent investigation, but the level of independence that exists in certain kinds of companies is kind of questionable at times, and that means that there's certain kinds of companies or certain entities that should absolutely be engaging a third-party independent investigator to deal with any types of these investigations. If the investigator is not independent of the employer, it can create a lot of issues for the employer, and it can, be more likely to result in a finding that is not necessarily supported by whatever it is that you've reported to the employer or whatever evidence is available, because that person is obviously compensated and related to, in some capacity, the employer, and therefore not independent. In the event that you have any kind of issues like this, I would suggest that you contact our office and have somebody sort of walk you through, talk to you about sort of your options and the ways that you can go about dealing with this. I generally advise that employees contact a lawyer pretty much anytime that they think that they should maybe be contacting HR, unless the issue is something sort of clerical or administrative. So something like vacation pay not being paid, you don't need a lawyer for that. But anything relating to harassment and sexual harassment, it's probably, generally speaking, a good idea to speak to one of the lawyers in our office and have them sort of walk you through what the next steps might look like, what your options are, and give you a fair evaluation of your evidence, the circumstances, and whether it would meet the legal threshold for harassment, because that threshold is higher than just feeling a way about something, to put it sort of very plainly. For something to be harassment versus something to be legally harassment that could be pursued through the Human Rights Tribunal, through a civil claim, or otherwise, it doesn't necessarily line up. And the advice that you might receive in that circumstance, where it doesn't seem to quite meet that level, is likely that you should develop a certain type of or take certain steps to develop like backup and evidence and something to support your claim further, or remove yourself from that workplace, or I guess it depends on the circumstances very, very greatly. But generally speaking, it's a good idea to speak to a lawyer if you need to speak to HR about anything that is not clerical or administrative. HR is employed by the employer. So as I was speaking about before, their sort of role is to act as a shield for litigation for the company and to deal with some of these issues before they would ever get to our desks. But realistically, the advice or support you're receiving is not independent of the employer, and the employer's goal is that this gets resolved quietly. So that's my kind of rant, I guess, about that. So you can always contact our office and have a discussion with somebody to sort of work your way through the situation that you're finding yourself in, as well as the like next steps, if that is what is advisable. Justin from Facebook asked, I'm being forced to quit by my employer and have to make a decision today. What can I do about this? I've received no negative feedback and I'm not sure where this is coming from. I think that you should contact our office. I think that you should not agree to anything whatsoever. Do not sign anything. Do not put anything in writing that allows them or would constitute something like a resignation. However, forced resignation is not valid at law. A resignation has to be freely given and voluntary and expressly confirmed by the employee employee and cannot be, pressured or given under duress in any capacity. If your employer is forcing you to quit by doing something like cutting your hours, or reducing your pay, or something that just isn't like a tenable situation and isn't the terms of employment that you had initially agreed to, then that could constitute a constructive dismissal. But I'm not totally sure from sort of the wording what it is exactly that you mean by forced to quit. I'd be happy to elaborate a bit if you want to explain a little bit more about what you mean by forced to quit. But in any event, do not sign anything. Do not send a resignation letter. They cannot force you to quit. If it's a if it's a forced resignation, it's a termination. And in terms of what you can do about it, that's really all you can do until there's more information for me or one of my colleagues to sort of work off of to give you more specific or personalized advice. Kathy from YouTube asked, my daughter is a sales lead at her company for more than 6 years. She's been given working notice of about 3 months. Should she agree to this? Is she owed anything more? Kathy, I would suggest that your daughter contact our office and speak to one of our lawyers, schedule a consultation to discuss sort of generally her employment situation, and her termination package that she's been offered. Notice needs to include all elements for compensation that she would otherwise have received during the same period, but for the termination. So for a sales employee, I would guess that she likely is entitled to some sort of commission or draw. She needs to make sure that she's receiving that, and also that she's being paid anything that she would have earned during that 3-month period. There's a number of stats that sort of get considered in the event sorry, everyone, I'm so sorry, just 1 second. My computer's dying. My charger, I apologize, tech issues. So yes, with Kathy, 3 months sounds low for a 6-year employee. It's also not clear what that 3 months is going to look like. They're not allowed during working notice, if that's all they're offering, to change any terms or conditions of her employment. And she should continue to receive whatever compensation she would have otherwise received, without the termination happening. And so because of that, I would suggest that you have somebody speak to her specifically, having reviewed both her each of her contract, commission plan, and the termination letter, just to make sure that this looks like what it should look like in the event that she would like to do the 3 months of working notice. The factors that are evaluated are age, length of service, position, and the availability of similar positions in the marketplace at the time of termination, which would be the date that she was provided with the working notice. 3 months for 6 years sounds a little low, but it does depend on all of those factors, and that would include things like what area of sales she is involved in, how old she is, and also like what is going on with the actual language in her contract and in the termination letter. When you say, should she agree to this if she's being asked to sign anything, I would say absolutely not unless she's spoken to a lawyer. specifically who's had a chance to review her documents. Um, Most releases, which is what they would probably be asking her to sign, will have a clause that requires or confirms, acknowledges, agrees that the employee has received or has had the opportunity to pursue the receipt of independent legal advice, um, meaning that they've been given enough time and have had the ability, capacity, and so on to contact counsel and have somebody look at this. So if the concern has to do with a short deadline, she has to sign by Friday or something like that, um, she should just ask for an extension. I would say like about 90% of companies will agree because the release is sort of challenged in the event that you haven't had that chance had you asked for it. She doesn't need to advise that that's why. She can just say, listen, I'm not sure about this. I need another week to think about it and consider my options and get some advice. She doesn't need to say she's contacting a lawyer, but I would suggest that she does. Raccoon from YouTube. Hello. How's it going? Says if the employer's lawyer gives a legal opinion that one employee's multiple allegations were unfounded versus another employee's, I assume, response to those allegations, should that be the end of an investigation? I mean, I think that this is a bit more probably nuanced than perhaps the question relays, or perhaps what you have been privy to. Um, in any investigation circumstance where a lawyer is involved, that lawyer would obviously be hired and paid for by the company, even if they're a third party independent investigator who's not actually working for the company on a regular basis. So, like, not something like in house counsel or HR. They brought in somebody else to sort of, analyze and work through those allegations. So they may not actually be the employer's lawyer, as in the lawyer for the company. They may be, an additional party that's been retained. In terms of a legal opinion, I can't speak to that without looking at it. I assume what you're referring to is something similar to, or something like a report that would have been provided by the lawyer who did the investigation, after having, interviewed you and interviewed the other employee and sort of done whatever other steps they deemed to be necessary, which usually involves a number of additional interviews with sort of witnesses and other people in the space, if there's toxic workplace allegations, that kind of thing. It doesn't have to be the end of the investigation. As I mentioned at the very beginning, there is a process. Once you've reported a harassment situation that does in fact constitute legal harassment or sexual harassment, legal harassment and or sexual harassment, the Occupational Health and Safety Act kicks in. So OSHA requires that the employer ensure and maintain a workplace free from harassment, workplace bullying, and sexual harassment, among other things. And so, pursuant to OSHA, once you've made a report to your employer of something that does constitute harassment or bullying or so on, they are obligated to conduct an investigation. In this case, it sounds to me like they may have just hired an outside counsel to conduct that investigation, which generally means that it's more neutral and more, what's the word? More neutral and more like less biased or less inherently unconsciously biased than if it was somebody who works directly for the company. But that doesn't necessarily confirm that they are absolutely correct. it's an evaluation of the evidence that they received. If you don't agree with the initial results of an investigation, there is a process contained in the Occupational Health and Safety Act that an employer is required to follow in the event that you appeal or challenge the decision or the result of the investigation into your report. That process is outlined in the legislation and also on the Occupational Health and Safety Act's sort of website. There's a like a summary, kind of like a less legalese way to understand what your steps are. But generally, you are able to pursue an appeal process. If you're in Ontario, often that is going to ultimately end up being that the Ministry of Labor takes over the investigation or sends somebody in to, continue or add upon or, audit, evaluate the investigation that was already conducted. Whether or not this was a proper investigation would require significantly more information, including, who was interviewed, who you advised should be interviewed, whether or not those people were in fact spoken to, what the circumstances are, what you're meaning by, quote, really long list of bull, which appears to be, and is the only information that I have about what these multiple allegations are. If you have concerns or want to understand the process better, or want some sort of guidance with respect to the report or legal opinion that your employer was provided, and maybe like a personalized explanation, etc., you should contact our office and schedule a call with one of our lawyers who can review all of the documentation ahead of time, and then would be able to speak to your specific situation and sort of what their thoughts are on moving forward with an appeal. And whether or not that's worth your time. But it does kick it out of the employer's direct contact and puts it into sort of the governmental bodies pretty quickly after the appeal process is initiated. By pretty quickly, I can't speak to how quickly they actually show up and do the things, but it does mean that it's sort of taken out of their hands. So if you have concerns, that is an option, but I would probably recommend that you speak to somebody who you could sort of describe what's going on a little bit more clearly, and provide those documents that you're referring to, so that maybe you can get a better explanation or a better understanding of sort of what's been going on and why that finding was made, and whether legally an appeal might be successful. Sabrina from YouTube said, I quit in April. Employer and I agreed that I will stay on until August. Employer changed that date until the end of May. The labor board wants me to file with them to go after 2 weeks severance. Is this a possibility? I assume what you're saying when you say I quit in April is that you gave notice in April, and that the August and or May dates were sort of negotiated timelines or negotiated notice periods that you agreed with the employer were appropriate for whatever your position is. It looks like you've already gone to the Ministry of Labor and filed a complaint of some kind, or considered filing a complaint of some kind. And I mean, of course it's possible. You certainly can file a complaint with the Ministry of Labor. If that's the advice that they're giving you with their sort of internal counsel, or maybe their helpline that you would have spoken to, then yes. I mean, if that's how you want to proceed, sure. The the reason likely that they're telling you that, and I assume your question is based on the fact that you quit. Like, are you entitled to anything because you resigned voluntarily? But you provided a specific period of notice, and the employer agreed to that period of notice, and then the employer unilaterally changed that date. The rules about notice and working notice and what happens during that notice period are that nothing is supposed to change from what it would have been if you hadn't been terminated. So, um, from the time you quit or gave notice until August, as per agreed, you should have been able to continue to work as per usual, be paid as per usual, be entitled to all of the benefits, etc., that you would have otherwise gotten. Um, the employer is not allowed to do something like shorten your notice period without your consent and agreement, especially when that notice period that you've provided or working notice that you've provided is like sort of specified and agreed to early on. And so, because they did so, you may have a claim for a constructive dismissal or a basis for constructive dismissal. Because basically, if there's big changes that happen without your consent, even if it's during a period of working notice, whether you were terminated or you resigned, as long as the employer is the one making those changes generally will contravene the Employment Standards Act. And since they are a breach of the Employment Standards Act and amount to constructive dismissal in most cases, depending on exactly what the changes that were made are. But I would say in most cases, they will amount to a breach of the Employment Standards Act, and they will potentially have a constructive dismissal claim. If you have a constructive dismissal claim, then even though you have resigned, you would be considered, I suppose the labor board, it looks like, is telling you that they would consider that to be a termination in the circumstances. And I have pursued cases on that basis, that the notice is not valid in any capacity. Usually the notice that's provided by the employer, but in this case, the notice was agreed to by the employer. And then they contravened that agreement. I would say that what they're trying to tell you is that you may have a constructive dismissal claim that could be successful by way of administrative labor complaint. That said, it may be useful to speak to someone in our office who can sort of parse this out a little bit more easily and take a look at your employment contract if you have one, as well as any correspondence that does confirm the initial agreement, your resignation initially, the change, etc. It's pretty critical to be able to speak to these types of things with much certainty or specificity, for us to have a chance to look at whatever it is that you have that you believe supports the claim or allegation. You can certainly file a Ministry of Labor complaint without a lawyer, but I would still say it's probably worth speaking to somebody just to make sure that, you understand fully what it is that you would be putting into a claim like that, what your allegations are, and what their evaluation might be of the circumstances. This is my last question. JBK from YouTube said, I work in daycare. We have a family event coming up, which is mandatory. It's for 2 hours, but it states in my employer handbook will only be paid for 1 hour for any family event. Is this legal? I mean, like if it's a work event that is mandatory where you are expecting and required to attend and are doing so in some work related capacity, generally speaking, you would be paid for your time in the event, especially if you're performing work. This sounds possibly like something more akin to like a Santa party at Christmas where, colleagues can bring their kids in and there's a whole thing, which is a social event. it's a little unusual if it's a social event that it's deemed mandatory. So I would want to be able to confirm that. If it's mandatory, as in like they're saying essentially that it's the same as you working a shift, and there's a consequence and you have to show up, then I think that you have a stronger argument for being paid for the whole thing. If what you're talking about is that it's sort of more akin to, as I said, the Santa party thing example, and it's sort of like for fun and so on, it could be possible that the 1 hour is actually like sort of akin to a gratuitous payment. I would want to see the actual language in your employment handbook, frankly, and understand more so, more contextually what this event entails and what your role would be there, before I can really speak to it. So, I mean, if you're not clear, you could definitely call our office and schedule a consult. It's a little difficult for me to say generally without knowing sort of what your capacity would be in that space. Anyways, I hope that was helpful. And tomorrow we have another Facebook Live, I think. Yes. Tomorrow with Samara, we have another Facebook Live at 1:30 Eastern time. So if your question wasn't answered or you have further clarifications that you wanted to add, feel free to join us tomorrow. All right. Thanks so much.